we're back, and if you're joining us right now, we're just getting our second conversation for this morning started. And as we mentioned before the break, we are speaking about a very important topic, and one that perhaps doesn't necessarily get the attention that it might probably need. It's something that people don't know a lot about in terms of procedure, and that is about divorce. And we are joined by Darlene Vernon, who's an attorney at law and is going to break down the entire process for us. Good morning.
Morning, Darlene.
Morning, guys. How are you?
We're doing great. Well, I am doing good.
Yeah, no, I'm doing great too.
Okay.
Thanks for asking.
Very, very important topic. Simply because of what the world is right now. Mm-hmm. What it's going through. I was looking through some data, and there are some countries, for every 1,000 people, there are about 5 or 6 point something divorces going on. The pandemic actually put people in households together. We know that some folks might not be as compatible as they have thought. Marriages that occur very early, not knowing your significant other. What is the current situation? Before we break down the process, mm-hmm. let's talk about the current situation in our country. What have you been seeing?
Well, without a doubt, there has been an increase in divorces in Belize, without a doubt. And I think that was one of the driving forces behind us doing a recent amendment, mm-hmm. which now allows divorces by consent. And so, the courts, and I guess by extension the legislative, they're recognizing that you can't force people to be together who no longer want to be together. And so without a doubt, it's an important factor. You have people, when they come for consultation, they're misled as to what really is the procedure, mm-hmm. what is required, and so forth, and whether or not they need to stay together. And so when you give them the proper advice that they need, then they go and they do what they need to. But again, without a doubt, we have seen indeed an increase in divorces in Belize.
What is, as an attorney, I'm sure you've sat down with a lot of couples. Mm-hmm. What is the biggest driving force to getting a divorce?
Because of the different grounds that I would say more than anything else, it's mm-hmm. always, well, not always, but it's usually either adultery or cruelty. Mm. Those are the driving factors behind divorces in Belize. Mm. Many people have decided that they don't want to air their laundry. So what they do, before we did the recent amendment, mm-hmm. they would just live separate and apart for 3 years. And that would be one of the other grounds they would come on without putting who really caused the end to the divorce, or to the marriage, mm-hmm. I should say. Mm-hmm. But without a doubt, it's normally cruelty and or adultery.
Wow.
And it's interesting that you said that, mm-hmm. because you mentioned, I think the first thing, in the first, you had said, you can no longer force people who don't want to be together.
Correct.
And then you brought up just now the grounds of adultery, cruelty, and you talk about the idea of who caused the end of the marriage.
Correct.
And I think that that introduces something which a lot of people don't necessarily know. You and I would know, mm-hmm. But that's talking about the history of divorce, and talking about how it used to be. It used
Correct.
to be much harder to get a divorce.
Yes.
Back in the days than it is now.
Correct.
And that's because of what you used to have to prove that somebody else was wrong, right? So you could talk a little bit about the old days.
Okay. Well, indeed, under our laws, first of all, before you could even contemplate getting a divorce, mm-hmm. you had to be married for at least 3 years. Mm-hmm. Yes, you had to be married for at least 3 years before you could even approach the courts for divorce. And at that point in time, we had only fault-based grounds, which mm-hmm. were either adultery, cruelty, desertion, or that the person was of unsound mind. And so you had to prove those. Mm-hmm. Yep. You had to prove that the person committed adultery on you, that, mm-hmm.
He
was being,
He or she,
yes, let me not be gender biased. He or she, exactly. We're stepping outside of the marriage, for lack of a better word. Mm-hmm. That the person was cruel, and cruel doesn't mean physically hitting you. It mm-hmm. can be emotional, psychological, financial cruelty. Mm-hmm. Mm-hmm. And then you had to prove either desertion, that the person has just decided to up and leave you for 3 years, and then you can pursue your divorce. Or, as I said, unsound mind, where you have to get the certification to show them that this person is not capable of actually being in a marriage and understanding what is required. Mm-hmm. You literally had to prove those mm-hmm. things before they could be given, before the divorce could be given. And then obviously we made an amendment years ago which said, you know what, let's introduce another ground. If parties have been living separate and apart for 3 years, mm-hmm. and the marriage has broken down irretrievably, and there's absolutely no way you can say you're going to get back together mm-hmm. and reconcile the marriage, that will be a ground. But again, under that one, you still had to be married for at least 3 years. So those were the fault-based grounds.
So that's the old way of how it used to be.
Correct.
Ah.
Recently, we did an amendment, and now they're allowing divorces by consent.
Which means?
Which means that if you and I, we were married, and we said, you know what, this isn't working anymore, I want to get a divorce, and you can agree, because previously you couldn't agree to a divorce.
You had to wait
could not
those
have
years.
collusion or, correct. You could not agree. It had to be someone caused the breakdown of the marriage. So the new amendment that was made under the Act says that you can consent, but you still had to be married for at least 1 year, not 3 as previously dictated by the law, but no, just 1 year, and then the party can consent, you sign the document, and this is the only time a signature is needed. I've found that most times when people come for consultation, they're under the impression that regardless, the other person must sign for the divorce to be given. I'm like, no, our laws are not like the US. There's no need for a signature. So now the only thing, or the only time that you require a signature is where it's by consent. Obviously, you know, the person has to show that he's consenting.
Yes, he or she.
Correct, he or she, sorry.
But you know, I find this to be very interesting, because I know of various couples whereby please go sign the paper because we need to get this situation.
Correct.
So you're saying now that only one person needs to sign. Am I getting this correctly?
No, previously, and even now, if you come on adultery, cruelty, desertion, you still don't need them to sign.
Yep.
The only time that you will require the other party to sign is if you're doing it by consent. But if we're divorcing and I'm bringing an adultery on him, my only requirement would be to serve my petition on him. He will read and see what it is that we're indicating as to why the marriage broke down, and it's up to him to decide whether or not he wants to challenge it. And there are certain procedures that he will follow to do that. But as it relates to my indicating to him, this is my intention to bring this divorce, then that's it. I don't need his signature. I don't need his consent. The court will decide whether or not I've satisfied the grounds that I need for my divorce.
And I think that begs a question that we can just jump into the whole procedure.
Correct.
Where does it start? If let's say somebody comes to you and let's say that it's not by consent, it's perhaps it's irretrievable breakdown or whatever it is, and somebody comes to you and says, I want to get a divorce, and assuming that they check the boxes, they can. What's the first thing that happens?
Well, you get the information that you need. You need to find out what grounds they're going to bring it on. If it's adultery, you need to get from them sufficient in your mind so you know you've been practicing for enough years, so you know what would be required and whether they satisfy the grounds in order to bring it for adultery or cruelty. And then you take that information and you put it in the petition. So the petition will have where you guys were married, whether or not you were married before, or a widower or a divorcee. If you're citizens of Belize, your addresses, where you work, if there are children of the marriage, minors and so forth. And then of course you will stipulate what the ground would be. And so the person signs the petition, and once that is signed, then you lodge it with the courts. When that is received from the court, then you get your process server, police officer, to serve it on the individual. And when that is done, then that really initiates the process, because then it's going through the courts. After that, I do want to say that there are 2 ways now that the divorce can continue from there. It's either going to be challenged or uncontested. Meaning if I serve you and you see in my petition, I'm saying, you committed adultery against me, and you know that's an absolute lie. Obviously, you may want to challenge it. And so now it becomes a contested divorce, meaning we're going through a full-blown trial to show the court whether or not this ground that you're alleging against you is true. And if I can't prove that indeed you committed adultery, the court can say, no divorce for you. Yes. So that's one of the first things we do. And this is why the consultation is so important, you know, because you need to get the evidence from them. You need to let them know. Now, obviously, we don't expect you to come with a video or a picture showing, you know, the individual in a compromising position.
Although you used to have to.
Yes, it was more stringent then. But what the court does is look at it in the context on a balance and then determine whether or not that would lead one to believe then that you're stepping outside of the marriage or doing something that you shouldn't.
Okay. So, very interesting. Very, very interesting. And then the process or the timeline for these things to happen. How long does it take?
Okay, if it's not challenged, it's a much quicker process. It can go anywhere between 6 weeks to 8 weeks. The reason why it takes a little bit longer is because there's a time period between the decree nisi, which is when the court says, okay, I've heard your evidence and I've decided that you've satisfied the grounds for the divorce, and the final document which actually brings the divorce to an end. And the reason the court grants that grace period is because sometimes people don't understand the severity of the steps that they're taking to get divorced. And they realize, you know what, I want to give a second chance with my wife, with my husband, and they reconcile. So if they do that within the time period, then we just don't file the final document or we withdraw the divorce completely. And they're still married despite the fact that the NISI has already been given, because the NISI is just saying, yes, I've been satisfied that this person was guilty of this wrong. But it doesn't stop you from reconciling if you wish. And so when that time period passes, which again can be anywhere from 2 weeks to 4 weeks, then the divorce comes to an end when the decree absolute is issued, meaning we haven't heard back from you. You indicated you don't want to take back your wife, and so the final document is lodged by us.
Is it an expensive process?
Normally, uncontested, unchallenged divorces would range from $1,000 to about $2,500 because it's a very straightforward process. That's just the attorney's fee. The filing fees tend to be a bit more. We recently did some amendment to our fees overall, so some of the costs, they have doubled. And so normally, while the filing fees would have been about $250, now it's around $400. So you're looking at maybe divorces costing you $2,000 to $2,500 unchallenged, uncontested. If it's contested, can go anywhere from maybe $5,000 to sometimes $20,000 because it's a full-blown trial. It's dependent on the number of witnesses, on the number of documentation, submissions, exactly. So it ranges depending on what type of divorce you're pursuing.
And you know, you mentioned something that's very important that we haven't really talked about, and that is if there are children of the marriage.
Correct.
And what are the considerations that would apply in that situation?
Okay. Well, normally in the petition, you'll already indicate what you want to happen with the children. So you either say you want sole custody, joint custody, and if it's joint custody with care and control to you, meaning you're the primary parent that the child will live with, but the other party will still have a say, will still have access and visitation. But that just indicates to you what it is that you wish to do with the child. If the other party is challenging it, then there's the entire process you'll have to bring again now, whether it's the petition for maintenance for the child and custody to see who should get sole custody and so forth. If the other side is not challenging it, then it's easier because the court will say, well, who is the child residing with? And if the petitioner said, well, the child has always been with me, and we served the petition on you, and you saw where the petitioner is saying, I want sole custody or full custody of the child, and you never bothered to challenge or otherwise, then in those instances, the court will grant it. But if it's challenged, then that's going to be up in the air until the court hears the evidence as to who is best suited. I do want to say, because most people are of the impression that when you're married and you have a child, that automatically mother is vested with full custody or sole custody, and that's not the case. When you're married, it's automatic joint custody. Unless, or well, I should say, contrary to that, where a single mother, not being married, then she is vested with sole custody. But if you're married, it's automatic joint custody.
And that have always been the case, not in the new law.
Correct.
And how long have this new law been in existence? Now I'm saying this because, like I mentioned, I've heard of a lot of couples saying, you know what, we need that signature that this person is actually giving me the runarounds, not wanting to sign it, and we're talking here both men and women.
You're talking about the consent?
Yes.
If I'm not mistaken, about a year and a half now?
2019, I believe, is the divorce by consent.
By consent, yes. So about a year and a half going on to 2 years that you're now allowed to bring divorces by consent.
If you divorce from somebody, me and you divorce.
Correct.
But we ended up probably a year or so reconciling. Are we able to get married again?
Trust me, you can. I've seen where I went through a full challenge divorce, husband and wife battling. 3 months later, after they got their decree, I heard they were remarried again. You can. You can. If I give you your decree absolute tomorrow, you can apply to go and get married immediately after.
What?
Yes. Because you're no longer legally married. So that's possible.
And, oh yes, so one important thing we also haven't spoken about is how we divide assets or property. Okay. And that's, of course, a very, that'll be in a lot of people's minds because, and some people don't want to divorce because they think, oh, I'm going to lose
the
half
house.
of my house, or money. I'm going to lose whatever, I'm going to lose all of my bank accounts. So talk a little bit about that process and what the court looks at.
Break that down for us.
Okay, well, division of matrimonial property is triggered by the divorce. You cannot bring a claim for division of property without first initiating divorce proceedings. That's the law. So you can't say, you know what, I'm still going to be married, but I want the court to determine that I'm entitled to 50%. No, you have to initiate divorce proceedings, and then you're allowed now by a separate summons to bring division of matrimonial property proceedings. So you're going to go through an almost entire trial process. In there, you're going to list all the assets that you've had, and what the law looks at is what was acquired during the course of the marriage. And even though it says during the course of the marriage, if you went into the marriage with assets, but during the course of the marriage you developed or otherwise increased the value of that, the court can also look at it because that development happened during the course of the marriage. And then what you have to prove now, after you've listed everything, is to show the court why you're saying you're entitled to such percentage, whether it's 50, 60, less. And the strongest means, of course, is financial contribution. If you have financial contribution, and you can show the court, well, I helped to pay the mortgage. While he was paying the mortgage, I paid the utilities, you know. So the court looks at that in making a determining factor. And then one of the other things that the court looks at is what is stipulated in the act, which is the contribution by the respective spouse, what you did as a husband, what you did as a wife. And so those are the things that they would look at in making a determination as to the percentage required for each party.
All right, so really very interesting situation going on here. As a matter of fact, we also have some online questions for you.
Okay.
And Caleb is asking, what happens if it's a cross-border marriage?
Okay. If you were married outside the jurisdiction of Belize?
Yes.
That's what you're asking.
I think that's it. The question is just what happens if it's a cross-border marriage?
Right.
I would think more than likely it's what you mentioned.
And the parties are Belizeans?
I would think that too.
Yes, then you are able to bring a claim in the Belize court for divorce. And likewise, if let's say you get married to someone who's not of Belizean nationality, upon the marriage, the wife would assume your nationality. So even if you're the one choosing not to bring divorce petition, she can bring it because she assumes your nationality. So by extension, if you recall earlier, I was saying you would list in the petition whether you're citizens of Belize and so forth, because the court would need to have jurisdiction over you. So if these parties got married in Las Vegas, got married in Mexico, they're still Belizeans, and we have jurisdiction over them. So yes, they can get their divorce in Belize.
All right. Another question says here, what happens if surrogate child?
Surrogate child?
That's the question here. What happens if surrogate child? I guess maybe if it's a surrogate child.
Okay, if the thing about children is that you have to show that the child is legally adopted or that the child is yours biologically. So if you're unable to prove those, then you can't show or ask the court to then have jurisdiction as it relates to custody. What the family courts have been doing, even though you have to prove paternity, even though you have to prove that the child is biologically one of the partners, you have to prove that the child was also treated as a member of the family or a child of the family. So in the family court, that's a little bit different, where you can then get maintenance and so forth. But as it relates to custody, you have to prove paternity or show that the child is legally yours. You just can't get a child and say, this is mine, without proving documentation that, you know, the child actually derives some sort of title through you.
So, question, what are prenuptials and how do they affect a marriage?
Prenuptial agreements,
Yes.
while not necessarily fully enforceable in Belize because we don't have any laws that speak to prenuptials, what the courts have been doing is when parties enter into settlement deeds or settlement agreements as to how they would want the properties divided and so forth, during the divorce proceedings, that agreement can actually form a part of the final document. And so they can use that as an agreement that's enforceable. So if one party should break it, you can go to the courts and have the court enforce it. But we don't necessarily have prenuptials that are enforceable in Belize, so to speak.
All right. Is there anything else we should know about this situation? Very interesting, though. Very interesting. Anything else you'd like to share with us with respect to marriages, divorces in our country?
Well, as I said, the grounds, you have to satisfy one of the grounds in order to be able to commence divorce proceedings in Belize. That's without a doubt. The new ground, which is the consent, actually allows you to get the divorce through quicker. It goes faster. Because where the other party is consenting, the time between the nisi and the decree that I had explained earlier where you could reconcile, sometimes they only give 2 weeks and that final document can be issued because the court realizes that the other person has consented. So he himself has no, or she has no intention of actually, getting back into the marriage. So those are the main things. And then as I said, everything else stems from the divorce, whether it's division of matrimonial property, whether it's maintenance for the wife, because we haven't changed our laws yet where a male can apply for maintenance. So it can only be for the wife. But all of those are triggered as a result of the divorce proceedings.
Question here, what are my options other than divorce?
You can do legal separation. That is done through the family court. And I'm glad that someone brought that up because most people are of the belief that legal separation is almost equal to a divorce. It's not. All it does is allow the parties to live separate and apart without one other party alleging the other deserted him or her. It doesn't mean you're free to go there and get another person because that's adultery. You're still legally married. A legal separation only allows you to live separate and apart. That's it. Not to go and get with Jim or Jill or no, because that's adultery. And the other party can use that against you.
That's serious. Go ahead.
No, absolutely. And I think, just to round off the discussion, just very briefly, I think since they brought up the topic, maybe we can talk a little bit briefly about perhaps annulment or marriages that there's certain kinds of marriages are void from the start.
Correct.
People may be under the belief that this is valid or that there's an actual marriage, but it is not. First, and there could be several reasons, so perhaps you can talk a little bit about that, just to clear up some misunderstandings.
Yes, great, because we do have some more questions coming in, but continue with that.
I haven't touched annulment in a while, but from my pure recollection, if the marriage is not consummated, meaning that after you got married and no one engaged in sexual intercourse, obviously the marriage has not been consummated and a party can apply for annulment. If upon entering the marriage you realize that the person that was of unsound mind and not mentally and legally fit to enter into the marriage, that's possible. There's also the ground of deceit where the person entered the marriage upon a fraudulent means or, entered the marriage already pregnant for someone else and, not disclosing that to the other party. So those are grounds where, and obviously you would know. So marriage in most instances would not be consummated in any event. And so those would be grounds that you can tell the court, well, you know what? I want an annulment as opposed to a divorce. And the effect of the annulment is as if the marriage never took place versus that of a divorce. The divorce is evidence of a marriage having taken place, but which came to an end. The annulment is as if the marriage never took place.
And of course, it's important to bring up bigamy.
Oh, yes, and bigamy, yes,
You can't be married,
yes.
All right,
yes.
so there are so many things here. All right, so it says here, and this is from Nuds, it says, what happens if you have proof of adultery and desertion of spouse and that person still doesn't want to sign?
No, but as I'm saying, for those fault-based grounds, you don't need a signature. There's only one instance where you will need a signature, and that's if you want to do it by consent. We agree that we're going to get a divorce. That's the only time you need a signature. But for fault-based with adultery and cruelty, you don't need that person to sign. You're going to allege what all this person did, file your petition with the courts, serve it on them. If they choose not to answer, good for you. You have an uncontested divorce and you'll get it on whatever ground you have there. But you don't need the signature where you're alleging the person actually brought the marriage to an end as a result of some act or fault that they should not have done.
All right. So this one says, when will I be able to remarry after my divorce? But you did answer that. You could just done divorse and you could go
immediately and apply
next to the court and apply to marry.
Correct.
All right. Then this one says here, why it's that even you get the divorce, the ex-husband still have to maintain the ex-wife, even if they have no kids, and she asks for legal separation.
Well, there's a difference between legal separation and divorce. So, yes, a wife has the right to apply for maintenance if it is that the husband was the one that was really taking care of the family and she was dependent on the husband. Especially if it is that the husband had coerced the wife into not seeking employment. I want you to stay at home. I want you to just take care of the home. I want you to, just be there available for me. And so you encourage the wife then not to pursue any employment at all. And so she's dependent on you. And then you introduce her to this lifestyle. So she has the right upon divorce proceedings to tell the court, I want maintenance, I want alimony, and that the court can grant it based on the evidence that you've provided to them and say that, okay, you're going to get this maintenance until either you remarry or you die, or of course there's a choice that is given. If there's a change in circumstances, then the husband has the right to apply back to the court and say, I'm unable to pay this amount. Can it be reduced? Or right now I'm unable to pay at all. But those would be the reasons why the wife can still get maintenance even after the parties are divorced.
Even after divorce?
Yes.
Wow. All right. So that yeah, tough. But those are the questions that we have so far. Those are the questions. But, you know, we're so glad that we're able to clarify the situation, especially that of we don't need the two signatures, especially, you know, on certain grounds. So fault-based and stuff like that. There, you don't need an additional signature or the next person's signature. You just need to come bring that in. That person will be served, and then
the procedure follows
afterwards. All right. Gav, anything else?
I think that was, we touched on the major grounds and the major misunderstandings. And we certainly appreciate you answering some of the viewer questions.
No problem.
You know that a lot of people are under a whole lot of different misapprehensions about what the divorce is and what the process is. So Darlene, thanks for coming in this morning.
Absolutely no problem. It's my pleasure.
Man, it was great having you in. I can tell you, everybody glued to their TV wanting to know what the situation is.
Some people who are under lockdown, really.
And you know, it's funny when you said that you know the COVID situation and the quarantine caused a lot of divorces, and it has, because people are not used to being around their partner 24/7. You get that breather when you go to work and you come home. So now when you're, so it has caused a lot of, I will say it has caused an uptick, definitely, in consultation, in people saying, you know what, if I divorce my husband, what all do I need? What can I get? So that's definitely one unfortunate side effect of the quarantine.
All right. She is attorney at law, Darlene Vernon. It was great to have her in to explain to us the divorce situation, the proceedings here on Open Your Eyes. Dee, thank you so very much. Do enjoy your day.
Welcome.
And the remainder of your holiday, by the way. We're about to take our break, actually, and when we come back, we'll be joined by reps of Marie Shop's Fine Foods as they celebrate 40 years here at home. We'll talk to them when we come back.